It's my pleasure to introduce my partner, Clarence Webster. He's going to keep us on the ethical use of technology. He's going to be talking in particular about social media and litigation. Clarence is a partner at Foreman Perry in Jackson, Mississippi. He's a graduate of the University of Mississippi, more commonly known as Ole Miss, where he served as student body president. He's also a graduate of Yale's Law School. Clarence's practice focuses on appeals, mass torts, commercial litigation, environmental litigation, and product liability. Last year, he was named a Mid-South Rising Star in class action and mass torts litigation. Please welcome my partner, Clarence Webster.
Before we begin, to the extent anything I say is perceived as a knock on social media users, do not take it that way. I am a social media junkie. I oftentimes speak in hashtags, and when my phone dies, I go through social media anxiety disorder, often clicking the home screen even though I know the phone's dead. As many of you know, social media is ubiquitous in our society. It affects most facets of our daily lives. It affects how we consume news. It affects how we receive news. And now we are raising a generation of children who will grow up on the internet. As such, social media is a very, very important tool that can be used in litigation for myriad purposes. Social media is no longer just Facebook. There are now myriad ways and myriad platforms in which people share some of their most intimate and deepest thoughts, movements, and motives with the world. And all of these platforms have memberships that are, as you'll see, very, very high. So there are 7 billion people in the world. 1/7 of those people are active Facebook users. As you see in the first quarter of 2013, Facebook announced for the first time that they had gone over 1 billion active users. Instagram in May 2013 reported over 100 million active users, and Tumblr, which was used during the Boston bombing investigation and also used to fuel the Occupy Wall Street movement, they have over 109 million blogs with 77.6 million daily posts. And in December of last year, Twitter reported that it had over 200 million monthly active users. So why do people use social media? As you see, if you have a Facebook or Twitter or MySpace account, you have engaged in the use of social media for one of these 3 purposes. However, Harvard University recently did a study and came to the conclusion that the use of social media stimulates the same parts of the brain associated with eating food, getting money, and having sex. It stimulates the same pleasure area of your brain throughout. Also in that study, they found that people would turn down money to use social media. I think I would be in that group. The ultimate conclusion was that people love talking about themselves, and they love sharing themselves with other people. So as long as that is a human impulse, social media will be around, is here to stay, and we as lawyers have to find out the effective ways to use it in our litigation. Why should we use it in our litigation? To be honest, it is a better tool than voir dire. It is a better tool than a private investigator. It is a better tool than a jury questionnaire. People tend to lie to those 3 things. They do not lie when they're using social media. You can use it in your fact investigation, pre-claim. You can use it in discovery. It can be used in discovery to win and lose cases, especially in the employment context. Just to give you an anecdote, there was an employment case where the person was alleging sexual harassment, saying that there were some things in the workplace that made her uncomfortable. They produced some pictures from her Facebook page. The suit was immediately dropped. It can also be used for expert retention and preparation. Experts, law firms, individuals have started putting on YouTube the depositions, the video depositions of experts. So if there's a guy you want to check out, go to YouTube, see if he's already given a video deposition and if you can find it. It can also be used for jury research. For those of you who do not have Facebook and are not always on the internet, this is the type of information that you can get just from the info section of a Facebook page. I looked at my Facebook page and realized that I had disclosed all of this information to the entire world. And again, this is a valuable tool when you're investigating your plaintiffs or when you're doing research on your venire or your potential jurors. Things that aren't listed up here, I was just looking through my own Facebook page, the books I like to read, the movies I enjoy. These are all things that people openly disclose on Facebook. You can also use Facebook to monitor a juror's activity during trial. And depending on what side you're on, that could be a good or bad thing.
It started off as a seemingly innocuous chat on Facebook. Joanna Frail found Jamie Stewart on the social networking site and struck up a conversation about a drugs case that was going through the courts. The only problem was Joanna was a juror on the trial and Stewart was an acquitted defendant. When the judge found out, the trial collapsed. And now Joanna Frail, the juror, has become Joanna Frail, the prisoner, convicted with contempt of court and sentenced to 8 months in jail.
What you did.
Jamie Stewart was given a suspended sentence. She says she's devastated about what's happened to Joanna.
I feel sorry for the woman. I seriously do. She's a mother and I've seen how upset she was and I felt for her, so...
It's the first time anyone has been charged with contempt of court or spoiling a trial online. But the Solicitor General Edward Garnier QC says it's made very clear to all jurors that they cannot research or contact defendants.
Judges do warn jurors not to research on the internet. It should not be a polite request. It is an order of the court.
Judges at the High Court accepted there was no intention to ruin the trial on the part of either woman and that Joanna Frail had admitted her guilt as soon as possible. But they said the law was very clear.
So this was a pretty high-profile trial, and it ended up costing the government several $1 million retrying the case based on the activity of these two jurors. Another way that you can use social media, YouTube is another great example, is for deposition prep. If you have a witness who's never been sat for a deposition or seen a deposition, you can show them a deposition from YouTube. If you know the plaintiff's firm, you can Google that firm and see if they've ever given a video deposition.
Have you ever had a claim brought against you before like this one, a legal claim?
No, sir.
Okay. So your jurisprudential hymen is being ruptured?
We promised y'all a treat. You got it.
Isn't that what you just told me?
I would.
Hey, I just thought of that.
I would.
Wait just a second.
I would. No,
I got to check the form.
I would characterize it more as my jurisprudence rectum being stretched.
He wins. Dr. Watson wins that round.
As you can see, this witness was neither prepared for the quirkiness of his plaintiff's counsel or for the question. So if you know that you have a plaintiff's counsel who's going to be a quirky guy, these are things you can show your witness ahead of time so that he's prepared for things like questions like that. Next, I'm going to talk briefly about the use of social media with your employees. This is a British Post. And I'll give you a second to look at it, but someone was not very happy with their boss and decided to share it on Facebook. The person obviously forgot that their boss was one of their Facebook friends. As someone said earlier, the National Labor Relations Board does not allow individuals to be fired in the United States for making comments about their bosses. In NRA, American Medical Response of Connecticut, the NLBR applied the concerted activity provision of the NLRA. Just to give you an analogy, it's the section that protects unions to say that individuals could use social media to complain about their work conditions. There has also been a finding that employees have a common law privacy right in their off-duty conduct, including social media. That being said, employers have a legitimate interest in their employees' use of personal social media accounts to protect trade secrets, to avoid liability for defamation, and to avoid damage to the business's own reputation or brand. Therefore, if someone says, going back to the Dilbert cartoon, we make a dangerous product and we know it, that person could be fired for putting that on Facebook. As a general rule, employers cannot request an employee's social media passwords. There may be some exceptions to that rule. If you are going to do that as an employer, I would check with your in-house or your outside counsel before doing so. As far as getting social media information in discovery, with all discovery, the relevancy standard applies to requests for social media information. Just to talk about one of the cases, the first case, the EEOC versus Simply Storage Management case. This was a case filed by the EEOC on behalf of two claimants who alleged emotional distress arising out of sexual harassment that they alleged was occurring at Simply Storage. The EEOC took the position that they only had to provide to the defendants communications relating to the allegations within the claim. The defendants took the position that they were entitled to complete access to all social media information. The court came to the conclusion that the defendants were entitled to any communications that relate to the damages being alleged in the claim. So if there were any communications that talked about the mental states of the claimants, then that information was discoverable. The court also found that pictures and videos from the relevant time period could go to the mental state of the claimants, and therefore that information was discoverable as well. The court did find, however, that tagged photos from third-party individuals were not discoverable. You have to request social media information through the party opposite, not the social media provider. There are statutes and cases that are very clear that Twitter or Facebook or Instagram does not have to respond to a subpoena. All right. For those of you who have pages, if you're smart like me, they are private, so only your friends and close associates can see what you post. However, private pages are not privileged. So if a person has a private page and the court determines that the information on their social media page is relevant, that information can be produced in the litigation. A pretty good quote is down below that. If you even consider something for a moment to be private, it has no business being on the internet. Just as a practical tip, try to discover or on your informally whether party opposites or witnesses have Facebook pages as soon as possible. Sometimes or social media pages. Sometimes that can be hard to do because people have pages that are not under their real name. I had a case like that. It was a products liability case with a lot of young plaintiffs. During the deposition, I got their actual names. By the time I got back to the office and got to look up their pages, all of their pages were private. And as we'll talk about later, there are ethical rules precluding you from then trying to friend that person to get access to their page. So you want to get that information as soon as possible, get screenshots of it before it's made private. So at trial, how do you get this stuff in? Much like other evidence, the authenticity of social media data is primarily governed by, in the federal courts, by federal rules of evidence 104 and 901. In 901, they provide some illustrations on how you can authenticate evidence. The most relevant to social media being that you have testimony on it is what the social media information is, what it says it is, and also the authentication of social media pages by distinctive characteristics or corroborating non-distinctive characteristics with additional admissible evidence. The Maryland courts have applied this standard most recent in 2011 in the opinion of Griffin versus State. There, the state produced a Facebook page of a girlfriend of a defendant. The defendant objected. The evidence was let in. The higher court said that the Facebook page, or excuse me, the post was not properly authenticated because there was no proof that the person that the information purports to be from was actually the person who made the post. Even though the post had a picture of the person's age, and the person's hometown. The court set out 3 different ways that you could get in social media information or authenticate social media information, and those 3 ways are as follows. You can do it with testimony from the person whose page it is or whose information it is. You could also do it by getting the person's computer and showing that they used their computer to make the post, or 3, by getting the information from the social media provider, which, good luck with that because they're not going to give it to you. Massachusetts has a similar ruling. It is Commonwealth v. Purdy. All right, now to the ethics part. There is a dispute among the jurisdictions as to whether a lawyer may friend an unrepresented witness without disclosing the reason for that request. For purposes of this presentation, New York says you can, and there is an ethical opinion on that. A lawyer may also view the public social media pages of represented parties, but may not contact a represented party directly through social media. So it's very important to figure out if a witness or a party has a page early on, because once you notice that deposition, you expect that Facebook page or Twitter account to be made private. Much like in Britain and the United States, a lawyer may use social media to monitor juror conduct, but may not have direct communications with the juror. And the last slide, and Bobby talked about this earlier, a lawyer cannot clean up a client's bad social media post after the litigation has commenced. Bobby talked about the Lester opinion. The other opinion on the list is the Catterall opinion. This was a trademark infringement case over a food called Catterall. I have no idea what that is. The defendant, after the litigation was changed the profile on his Facebook page from the infringing material to some more innocuous material. The plaintiff then moved for a spoliation instruction. The court considered the 4 spoliation factors: control of the evidence, an actual suppression of the evidence, a relevance of the evidence, and a reasonable foreseeability that the evidence would be necessary for trial, and determined that an individual has control of their Facebook page even if that page is public. So it's not one of those deals where you can come back and say, well, defendant, you could easily go to my Facebook page and get these pictures. It is incumbent on the person owning the page to maintain the page. The court in this situation said that with regards to factors 2 and 3, it was kind of a close question because people change their profile pictures weekly. Some people change them, more frequently than that. And the court did not order a full spoliation instruction. There was no inference. There was no summary judgment. But they did order the defendant to put the page back as it was so the plaintiff could get a screenshot of it. So as you see, this is a favorite quote of mine, but social media can be used in a lot of ways if you can just avoid the pitfalls and make sure you know how to get it and get it in. And I have 14 seconds, and I have gone the entire time with a social media presentation without mentioning a certain New York mayoral candidate, which was #difficult.